Today, in a devastating blow to the fight against the climate crisis, the Supreme Court limited the EPA's ability to regulate the power sector while taking aim at the ability for all agencies to regulate. And we'll talk about this ruling, but I note that it's just another attempt at this radical court's agenda to really roll back all the advances made by struggles for equality and justice, and it requires an intersectional womanist response. So today, the Roberts Court sided with the Republican efforts of coal-producing states and held that the EPA does not have the power to regulate the energy sector so that it shifts away from deadly fossil fuels. The history here is that an earlier Obama-era attempt to regulate emissions called the Clean Power Plan was previously stayed by the Supreme Court. Then the Trump administration tried to replace the Clean Power Plan with a toothless rule that was also struck down, this time by an appeals court, because it essentially shirked its own responsibility to regulate. Today, this ruling was brought by West Virginia that demanded that the EPA be limited in its power to regulate, even though the Clean Power Plan was never implemented. So in essence, this opportunistic case rules on a regulation that does not exist and never took effect. To do so, the majority unveils what it calls its major questions doctrine. What is this? In its normal course, judges look to something called statutory interpretation, or looking at the plain text of a law with a pinch of common sense to see what Congress intended. Now, the Supreme Court says that in extraordinary cases, the court itself should decide if an agency has overstepped. That means the court can essentially cherry-pick agency rules it wishes to strike, and in this instance, as the dissent noted, appoint itself the decision-maker on climate policy. Here, as the dissent again points out, the Clean Air Act gives the EPA the authority to regulate stationary sources, in this case power plants, or any substance that causes or contributes significantly to air pollution and may reasonably be anticipated to endanger public health or welfare. Power plant emissions are, of course, poisoning the air and causing the climate crisis. The law also gives the EPA the authority to select the best system of emission reduction for power plants. But instead of looking at the plain language of the statute with a reasonable common sense lens, as is normally done, here the majority invokes this major questions doctrine and curtails the EPA's authority. So, absent congressional action, the EPA cannot implement a regime to regulate the power sector for emissions beyond individual power plant levels. So, again, this is just another plank in this radical Supreme Court's agenda, and the environmental movement must shift to an intersectional womanist lens and strong allyship with broader fights for racial justice and equality.